Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Punjab and Chandigarh ROC adjudication order for the violation of section 149 of the Companies Act for non-appointment of women director in the matter of the Seagull India Private Limited order passed on 3rd March 2022. In this case, the company named Seagull India Private Limited, having registered office in at Ludhiana, as per the provision of section 149 of section 1 of the Companies Act, every company shall have a board of director consisting of individuals as director and shall minimum number of the 3 director in case of the public company, 2 director in case of the private company, and 1 director in the case of one person company, and maximum of the 15 directors, provided that a company may appoint more than 15 directors after passing a special resolution, and in Proviso it is written, provided further that such class or classes of the companies as may be prescribed shall have at least one woman director. As per the Rule 3 of the Companies Appointment and Qualification of Director Rules 2014, Rule 3 mention a woman director on the board. The following class of the companies shall appoint at least one woman director: every listed company or every other public company having paid up share capital of 100 crore rupees or more, or turnover of 300 crore rupees or more, provided that a company which has been incorporated under this act and is covered under the provision of the second proviso of subsection 1 of section 149 shall comply with the such provision within a period of 6 months from the date of its incorporation, provided further that any intermittent vacancy of a woman director shall be filled up by the board at the earliest but not later than immediate next board meeting or 3 months from the date of such vacancy, whichever is the later. In explanation, it is written that for the purpose of this rule, it is here clarified that paid up share capital or turnover, as the case may be, as on the last date of the latest audited financial statement shall be taken into the account. Let's see the facts of the case. The company and its MD have suo motu filed application for adjudication of the penalty under provision of section 454 of the Act. Applicant admits their default and suo motu moves the application for the adjudication of the penalty under section 454 read with the section 172 of the Companies Act in respect of non-appointment of a woman director on the board of the director of the company within the specified time period, and thereafter appointing the director bilaterally. That the company had to fill the vacancy of woman director as per the Rule 3 after the vacancy caused by the resignation of the erstwhile woman director on 16th March 2021 by the date of the next board meeting, that is by 15th June 2021. However, the company fails to do so. That the company has defaulted in filing the vacancy of woman director within the stipulated time. That the company has made the default good for the appointing another woman director with effect from 26 November 2021. Thereafter, E-Form DIR 12 for the appointment of women director was filled with the ROC on 1st November 2021. Hence, the default has made good. Thus, the company and its director have failed to comply with the provision of section 149 subsection 1 in appointing the woman director on the board of director, thereby attracting penal provision against the company and its officer in default mentioned under section 2 clause 60 of the Companies Act 2013. Thereafter, a notice for inquiry was issued to the company on 7th January 2022 and is officer in default as per Rule 3, Sub-Rule 3, and a hearing was fixed for on 28 January 2021. With reference to the notice of the inquiry, authorized representative appear before the ROC on behalf of the company and officer in default on 10th February and was adjourned due to leave of the undersigned and asked for the time of 1 week. As per the request, hearing was adjourned and accordingly authorized representative appear before the ROC on 15th February 2022. Therefore, it is concluded that the company and its officer in default are liable for the penalty as prescribed under Section 149 subsection 1, read with the Section 172 of the Companies Act. Further, it is pertinent to mention that suo motu application filed for the adjudication has not been filed by all the officer in default, and notice may issue to the other officer in default. Also, it is worthwhile to point out that authorized representative in his submission made it clear that there is a mistake in the adjudication application regarding period of the default. He pointed out that the woman director was appointed on the 26th October 2021 and not on the 26th November 2021 as stated in the application. Also, aspect regarding appointment of woman director was confirmed from the MCA portal, and it was found that woman director was appointed on 26 October 2021. Further, on perusal of the record, it is found that vacancy of the woman director was created on 16th March 2021 and was required to fill up by 3 months, that is the 15th June 2021, in terms of the provision of Section 149 subsection 1 of the Act. The company appointed woman director on 26 October 2021 and hence period of default is from the 16th June 2021 to 25th October 2021, that is for 132 days. Accordingly, ROC imposed the penalty as prescribed under Section 172 of the Companies Act for the violation of Section 149 subsection 1 on company for the delay of the 132 days. So hence penalty is calculated as 50,000 plus 500 for each day of the default, that is the 132 into 500, total 50,000 plus 3 lakh. Maximum penalty that is the 50,000 plus 3 lakh, but that is wrongly calculated here, and final penalty imposed on the company, that is a 1 lakh 16,000, that is here total default amount mentioned and maximum limit for the penalty under this section, but final penalty imposed on the company, that is 1 lakh 16,000, that is calculated as 50,000 plus 132 multiplied by 500, total 1 lakh 16,000 calculated as here, and on the director 50,000 plus 500 per day, that is total calculated out 1 lakh 16,000. And ROC opinion that the penalty is commensurate with the aforesaid failure committed by the noticee, and penalty so imposed upon the officer in default shall be paid from their personal source or income. Further directed that penalty imposed shall be paid to the MCA portal only under Rule 3 Rule 14 of the Company Adjudication of the Penalty Amendment Rule 2019 under intimation to this office. And if any appeal prefer against this order, company may file appeal within the 60 days from the receipt of the order. Thank you so much for watching this update.